The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for the submission of 3 cases. The first case of Kyle Dornath versus Employment Appeal Board, and Winger Contracting is hereby submitted without oral argument. We will begin oral arguments today in the case of Martinez versus State. Are the parties ready? Thank you. It's my understanding Mr. Ranscht will begin.
Thank you, Madam Chief Justice, and may it please the court. You got it right in Morris versus Leaf. When deciding to pursue a wanted suspect, a law enforcement officer does not owe a duty to protect any individual driver from harm or injury inflicted by a fleeing fugitive. Both the district court here and Ms. Martinez agree with that general statement of law, but below, the district court concluded a statute, and that's Iowa Code Section 321-231 sub 5, nevertheless establishes a duty that runs from Sergeant Jepkes of the Iowa State Patrol to Ms. Martinez under the facts of this case. But it doesn't. The district court erred. Morris instructs that there is no actionable duty in this scenario because Martinez challenges only the decision to pursue, not any manner of driving during the pursuit. And further, even if a duty does exist under that statute, no reasonable juror could conclude on this record, which you have in front of you in video format and including audio as well, that Sergeant Jepkes acted recklessly. So you should reverse and remand with instructions to enter summary judgment for the state. It's important to emphasize here just how limited in time we are talking about in a window. From the time that Sergeant Jepkes activates his lights to initiate the stop of Scott Grimes to the time when Sergeant Jepkes terminates the pursuit, specifically because he says this guy's getting too dangerous. That's a little over a minute and 10 seconds, 15 seconds, something like that. From the time that Grimes runs a red light on Meredith Drive until Sergeant Jepkes terminates the pursuit, that's about 20 seconds. It's probably taken me longer to describe what happened than for it actually to happen, and you can see that in the dash cam footage. And so this is a very clear split-second liability issue. It's a split-second decision that Sergeant Jepkes has to make, first to pursue, and then to the extent that's a different decision to continue pursuing, it happens in a flash. Yes?
In Morris, it seems to me that our court kind of knocked that one out about 3 or 4 different ways. And one of the ways was, as you're talking about, saying that subsection 231 doesn't impose a duty, but it also talked about the recklessness. Where I struggle a little bit is looking at subsection 5 of section 231, where it says, consequences of the driver's reckless disregard for the safety of others. That strikes me as pretty broad. And so if instead of driving on on Meredith Drive, if a fleeing suspect were to be driving toward a playground full of children at recess, there still isn't any sort of duty to try to avoid a consequence that would put a fleeing driver speeding through that playground?
That would depend in large part on how the case that is before you would have been litigated, right? So in that instance, do you have the plaintiff claiming a specification of negligence from excessive speed? Do you have a specification of negligence from the plaintiff claiming there was a crossing guard with a stop sign and they blew right through it? And those are things that are here in 321, 231. This case is just litigated differently and not up to that level. The only challenge made here is to the decision to pursue, not to the speed.
That strikes me as slicing things, rather fine. Morris is now about 27 years old, and for better or worse, we've got a number of public duty cases recently. And I think the line that we've drawn in part is between omission and commission. So if the state or local official, for example, allowed the suspect to go and the suspect went and did something, that might be omission. But where there's a conscious decision made to pursue a suspect, and that arguably creates a danger for people that are on that specific road at that specific time, that strikes me as outside the public duty doctrine as we've articulated it in the last few years. Am I wrong?
Did it as you just stated, an omission, commission kind of dichotomy. But importantly, number one, in this case, Ms. Martinez agrees that the public duty doctrine fits here. But even in those cases, distinguishing between omission and commission, what the court has typically done is still say, this is, the public duty doctrine is the failure to protect the public from someone else's instrumentality. And that's what we have here. That is what, even under the language of Brees, of Phelps, of Farrell, this is that the officer didn't exercise care to prevent Grimes from colliding.
Clear that this, because the Court of Appeals had taken off from that very language in Farrell, and we made clear that, in that case, you also had a reckless driver, you had a drunk driver instead of a fleeing driver, but we said that doesn't let the government off the hook, the fact that there's a third party. It does if it's a nonfeasance type of situation, but that's not what we have here, right?
Doesn't let them off the hook from causation, that there can be multiple factual causes. But here we're talking about duty and breach, which are precursors to that. And even Phelps, too, discusses an injury to the plaintiff that's directly caused or inflicted by a third party. And again, that's Grimes here. Part of this is, I know that you face this in Farrell as well, but it's sort of an artful pleading issue. Is this failure to protect from Grimes, or is it you could articulate it either way, and some of the opinions say, hey, we recognize there's gray area. But another distinction from all of those public duty cases that you've just described that have been over the last few years is that another important portion of the public duty doctrine is it's about uniquely governmental functions, okay? So part of the reason that you've concluded the doctrine doesn't apply in certain scenarios is that the government isn't doing something uniquely governmental. So Phelps is an example of this. They were acting as a possessor or occupier of land, and that's something plenty of private parties do. But here, and Justice McDermott, I know you're the Hulk reference guy, but I'm going to go to a different comic book here. Unless we're talking about Bruce Wayne, there is not going to be any private person deciding whether to pursue. We're not going to have vigilantes out deciding whether to pursue and apprehend suspects who have active federal warrants. Those decisions are exclusively governmental, which is the thing that is missing from these other public duty cases that you've talked about. Really, those are all sort of premises liability cases, and they talk about the government creating a dangerous condition on the property. Well, the government didn't create a dangerous condition on property that it owned here. This isn't the state patrol creating a dangerous condition on the street Ms. Martinez was on or the parcel of property that she was on. This is just about Grimes, right? And so that's why the public duty doctrine can still apply.
Decision to pursue, does it make a difference what the suspect had done? So here we have a crime spree and an escapee from incarceration. Does that get factored in?
Get factored into recklessness. but the decision to pursue, not really. And even so, under the facts of this case, yes, we have a crime spree, yes, we have an escape. We have, as the district court found, basically a federal task force on this person, joint venture between federal, state, and local law enforcement, active federal warrant for this person. So, I mean, we're not talking about someone who stole a Tootsie Roll.
You said 321-231 doesn't apply to the conduct alleged here, the specification of negligence here, is that right? So assuming that we think that the public duty doctrine does not apply here, then what is the standard for liability? Is it negligence or is it recklessness?
321-231?
If you think it doesn't apply in this case, then what is the standard of liability?
Standard is recklessness, and the reason for that, I know that Morris is pre-restatement third, but the restatement third accommodates the notion that for policy reasons that are articulated and articulable, you can either find that no duty should run in a particular class of cases, or you can find that the duty should be modified. And so recklessness is a appropriate modification to whatever duty applies under Section 7B of the restatement third.
Recklessness here, why was the district court wrong in saying that that was a jury question?
The district court kind of flipped it on its head, right? If the standard is recklessness. What the district court said is, well, I think there's a fact question on recklessness, and so that informs whether a duty even exists, and that flips the standard on its head. First, we have to find a duty before we can get to recklessness. The district court was also just incorrect because you can decide this as a matter of law in exceptional cases, and so the video is in the record. The video is really important. Scott versus Harris tells you at summary judgment, you look at the facts in the light most favorable to the videotape. And in our briefs are cited several cases in which in scenarios like this in other jurisdictions, courts have found no recklessness as a matter of law based on several factors. And so one of them was the Delgado case out of the First Circuit. And there the court found no recklessness as a matter of law because it was a 2-minute pursuit that took 1.4 miles, and they did little more than attempt to keep a fleeing car in sight. That's pretty close to what we have here. There was no effort physically to intercept. There was no effort physically to make a maneuver to run this car off the road. And the Delgado court said that's extending the label reckless way too far. That's extending it beyond what it means and its moorings. And so the First Circuit said, we don't find any fault with the district court for looking at that and saying no reasonable jury could side with the plaintiffs. And that's the case here too. We've got a minute and 20 seconds of pursuit. Jepkes does little more than just try to keep Grimes in view. And we even have at the end, if recklessness is the standard, right? Recklessness is intentional, conscious disregard for safety. But here we have Jepkes narrating. Firstly, okay, he just ran a red light, he's getting worse. Okay, he's speeding up, he's getting away from me. Like, okay, it's too dangerous. He's swerving in and out of lanes, I'm stopping. That expressly is regarding public safety, not consciously disregarding it.
Testimony that he was going faster because of the officer's actions of being so close to him.
We have cited the Louisiana case, which had a similar affidavit from a fugitive, and they said that doesn't really add a whole lot. But that also ties back to kind of these policy determinations under the restatement third, that we don't want to incentivize people to flee the police. The police should have, first of all, we want them to do their job in pursuing and apprehending suspects. And secondly, we don't want to incentivize people to flee because they know that they'll be more likely to get away because now we've got financial liability on the other side of it. And so you can really consider that kind of just self-serving testimony for the plaintiff here. And it just doesn't add very much. The Mays case from the Seventh Circuit is pretty forceful even though that's a constitutional case, not a negligence case, but of kind of rejecting the notion that it is law enforcement that causes this kind of illegal conduct. So I just don't think it adds very much. Now, what would the limits be under 321-231? Number one, and the big one, is a challenge to the manner of driving, and that may still be difficult ultimately to succeed on, given the recklessness standard. But this case hasn't been litigated that way. It's solely a pursuit decision rather than anything about the manner of driving. Without any further questions, I'll talk to you in a few minutes. Thanks.
Thank you. And it's my understanding Molly Hamilton will be arguing. Thank you. You may begin.
Good afternoon. May it please the court, opposing counsel, Madam Chief Justice, and the court. I am here today to ask the court to affirm the trial court's ruling on the motion for summary judgment and remand back to the trial court. The plaintiff's position is that there was a threshold finding of recklessness, and there are facts to support that threshold finding to leave the question of recklessness to a jury, and therefore there was a duty owed to Ms. Martinez, and that there are facts to support that Officer or Sergeant Jepkes was involved or a cause of the collision between Mr. Grimes and Amber Martinez. Now, the plaintiff also agrees that Morris is still good law and that Morris is essentially the gold standard, and we're not asking for the court to extend that. We are also merely asking for the court to apply Morris. The major distinction is that in Morris, the suspect was already fleeing and already causing danger to the community at large, which is the reason that the court did not find that by chasing and by driving in a reckless manner, the officer was reckless. Taking a step back and looking at the facts in this case, the facts are distinctly different in this case. And given some of the filings, it's unclear whether the court has had an opportunity to review some of the radio communications and the actual pursuit video quite yet. So just as a review, all day long on the...
We have seen that video. Let's say that we agree with you on the duty issue, and that Section 321.231 imposes a duty on police officers to sort of balance the gravity of the crime and the threat to the public in going after the person, the suspect. In looking at that video, and I don't know that there was much that the state has said here that I would disagree with as I watch it. It seems as though the chase happens. Jepkes is behind Grimes. Grimes is moving quickly. Yes, it's at 5:45 p.m., but the cars at least seem to be kind of moving off. There's then a red light that is blown, and you hear Jepkes mention it. Sort of alarmed by it. And then you see Grimes veer off into opposing traffic. And you then hear Jepkes say, I'm out, basically. I'm turning off the lights. I'm done. It's as he's sort of going up a hill, he crests the hill, and right there's this crash. If the bar that 321.231 sets is recklessness, and recklessness is something that we can decide as a matter of law, why shouldn't we reverse the district court's summary judgment ruling?
There are a few facts I would like to add. The radio communications has Officer Jepkes for approximately 8 miles speaking back and forth with other law enforcement, following Grimes while he is not speeding, while he is obeying all traffic, and they are discussing how to approach him. And Officer Jepke says 3 times, if we don't get him in the right place, if he runs, if there is a pursuit, that there's going to be disaster, there's going to be a problem, 3 times. And so that is, to me, that is the not just probable injury, he is consciously aware of that risk.
Heard that big word if we get into this one situation. And so does that mean otherwise they should never pursue? Because that's always a possibility. So it tells me he was being very conscientious of if it reaches a certain point, that could be dangerous. And isn't that exactly what happened?
In a sense, it is, but that is a part of his conscious undertaking of that risk. He knows if Grimes takes off, if he pursues, then he is a part of that risk. If he does not chase Grimes, he is not adding to the risk. It is Grimes himself that is the danger to the public.
That almost sounds like you're talking about a negligence standard. I mean, the standard is a reckless disregard for the safety of others, right? That's a high standard, and you know, I think we've all watched the video. And the other question I want to ask is I compare this case to Morris, because I think both sides invite us to do that. There's some ways in which Morris, you know, cuts in your favor, but I think there's some ways in which it cuts in favor of the state. From what the officer knew here, this person was a federal warrant, escaped from jail. That sounds like someone who's more dangerous than the person in Morris who was just fleeing and had been involved in a hit-and-run accident. I mean, that is a more frequent occurrence. I saw somebody do that in front of me walking home from the Y the other morning. I mean, that than somebody with an escapee. So help me with that, because I see Morris cutting in both directions.
I would generally agree with you. However, factually, during the motions, in the pleadings, in the trial, or in the district court motion for summary judgment, there is some fact testimony from Sergeant Jepke where he discusses, and testimonies elicited and facts asserted, that he did not know what the felony was. He did not know what the warrant was for. He was not specifically aware of Mr. Grimes's violence to any people, was not aware of violence in the past, did not know that he had a firearm, was not aware of any, again, violence in his past. And so all that he knew was felony warrant and this walkout from the jail.
County has a more secure jail now, but which I think everyone thinks is probably a good thing, although some believe it's spoiled the town square a little bit. But normally you hear, you know, when you hear an escapee, that immediately to the layperson strikes one as somebody who would be dangerous, because in order to accomplish that act, you would have to engage in fairly risky conduct. That's the normal reaction, isn't it?
Would generally agree. However, the sheriff was very public about the circumstances very soon after this escape, about the lack of violence in the circumstances. And Mr. Grimes actually had been, you know, on the run, so to speak, for 10 or 11 days. The FBI was involved in this federal crime task force. The only crimes that were continuing to be alleged or committed by Mr. Grimes was stealing vehicles that had the keys in it. And these vehicles were, I think, you know, valued at...
Sort of a legal question. Is it your position that what's relevant is what the knowledge that was available to Officer Jepke, or is it everything that was known to the whole task force that was after Grimes that afternoon?
It is what is Relevant, or what is relevant is what was known to Jepkes at the time, because that is a part of the pursuit policy and a part of their risk balancing test, and also, again, has to do with, is this justified? Is the public already at risk, or are they not at risk? And so by engaging in this and putting the individuals and the drivers on the road, people walking their dog, people coming home from work, it was 5:45 in the evening, the sidewalks were close to the street, putting those people at risk justified by someone who steals vehicles and walked out of a jail and was never violent to the public at large or to any individual.
Rise to liability in your view, it's not the decision to initiate the stop, it's the decision to pursue after Grimes begins to flee. Is that right?
Correct, and there is a distinction, and I think opposing counsel was perhaps blending some issues. It's in the pleadings and in the plaintiff's petition, paragraphs 7 through 10, it's not just the decision to pursue. There are specific allegations about the driving and the actions that were taking place during the pursuit. So it's not about the decision to pursue, it's about the decision to undertake the risk that comes with the things that happen during the pursuit.
I mean, you have a suspect, somebody who has an outstanding warrant, who's stopped by law enforcement, decides to drive away. If they have any knowledge that this person may be a flight risk, then they're not supposed to pursue. That's what you're saying, and that if they do, then that creates a fact issue for a jury trial.
I don't think that alone creates a fact issue for a jury trial. One of the other, I guess, main points of the balancing test of pursuit policies in just these cases in general is the means or the ability to apprehend at a later date. And the police and the FBI did have a warrant on a cellular device that was in the vehicle with Grimes and Ms. Schultz. And so they had the ability to apprehend at a later date. A lot of these
I mean, at some point, if he's in a vehicle, they're going to have to initiate a stop and arrest him at that point. Unless you're saying that the only reasonable conduct, given what they know about this offender, is they have to wait until he's outside of a vehicle, in his home, in a store, on the street. Because at some point, they're going to have to chase him. Isn't that right? And you're saying that they can't do that, and it's reckless, if they initiate any sort of pursuit after somebody who flees?
I think it's about time, date, place, and circumstances. And
Too, I'm imagining if they knew and the investigation had to do with drugs, that's when the cops get really smart and start paying attention to windows getting rolled down and stuff getting thrown out the windows. This whole case is about stolen vehicles, right?
well, in the escape walkout, if you want to be correct.
And so, I mean, if he stops, I mean, it's pretty reasonable to assume that if he gets stopped, that the goods are right there. That is the goods. So can't that be taken into consideration too, along the lines of Justice McDonald's questioning?
Yes, that can be taken into consideration. And I mean, at some point, you know, the car runs out of gas, like you have to leave the vehicle. But again, it's time, date, place, circumstance, area. You know, that was, again, rush hour. There were many people out coming and going from work. The sidewalks were closed. There's no vehicle. There's no place for them to.
Why he should pursue. It's not dark, which means better vision. There's people out there who could get hurt by him. I mean, just by starting to pull him over, that guy immediately starts taking off. It doesn't take more than a block or so before he starts going too fast. So don't those things also argue in favor of, oh my gosh, there's a lot of moving parts here?
Pulling him over in that area is a congested area. So, and there's many people around. He wasn't a danger to the people until there was a risk of a pursuit and that comes with the risk of driving.
And everything kind of cuts both ways a little bit. I mean, we as we act day to day and we make judgments, we make countless decisions every day, we kind of assume the other people are acting rationally in their own world as well. And it strikes me that if you're the cop and you have this guy cornered and then he suddenly pulls out and drives away, that suggests that to me that somebody who's willing to engage in that behavior is themselves a risky individual and somebody that it might be really important to stop and apprehend because they're a danger to the public.
No greater danger than before, though. I mean, by adding another car there, by being chased, that is increasing the danger. He wasn't a danger before this happened, and yes, this is not saying the police should stop trying to apprehend him. It's again the risk that comes when you are engaging and driving in that manner in that area.
Determinative that as soon as Grimes pulled off into the oncoming lane, the officer quit chasing him, turned off his sirens, announced he was no longer pursuing.
Meaning that cuts off liability, or?
To me, the opposite of being reckless. As soon as he saw this driver was going into the oncoming lane, he stopped his pursuit.
My time has expired. May I just quickly finish this? I don't think so, because there were multiple other traffic infraction violations that took place before that and other driving maneuvers that took place that were a danger and a risk to the public way before the driving in the opposite lane. There was a red light that was run. There was a stop sign that was run. There were speeds 80 miles an hour in a 45, and there were other people on the road that could not pull over. Thank you.
Thank you. This distinction that we've kind of drawn out in Morris about a fleeing suspect who was already fleeing and causing danger, I think that's an illusory distinction. Here, Grimes was causing danger based on the crime spree, based on stealing a lot of vehicles over a 10 to 11 day period of being on the lam. Sergeant Jepkes even had testimony in the record in his deposition about the broader nature of the crimes as he understood them. And furthermore, just as in Morris here, in Morris, the officer was acting under orders from headquarters to pursue the driver in that case. And here, Sergeant Jepkes, likewise, he was acting on orders to pursue this person. We had a task force, we had a federal warrant, we need to get this guy. It's taken us a while to find him. That's why we have the first SUV on the video with the tracking equipment on the roof.
How is this chase ever going to stop other than running into another car?
Well, he could decide, okay, my time's up. Police have a reasonable expectation that people will submit to the stop when it happens.
And then he ran a stoplight, and there's a lot of traffic. I mean, at that, long before he went into, or some time before he went into the other traffic of lane, it's pretty obvious that he's not going to stop on his own.
And he is escalating his behavior, and as he continues to escalate, that's when you see Sergeant Jepkes say, okay, it's going too far. I'm going to shut this down. That's on the back end of the pursuit. You also have on the front end of the pursuit, Counsel referenced the discussion occurring before even the stop was attempted. Okay, if he runs, it's going to be a problem. Let's not try to stop him here. Let's try to stop him somewhere else.
Lends the other way, recognizing that if he runs, we're in a high traffic area and it's rush hour, and he did run, and he still chased him. I'm not sure which way that cuts.
Pursuing him when we're not pursuing at that point, but when we're driving behind him on Interstate 80, if he runs, that's a bigger problem because of the speed of traffic, the barriers, all of those types of things. What I'm getting at with that is having these discussions over the radio and determining, let's wait till he gets off the interstate, let's wait till he turns onto a side street to even try this, is the exact opposite of conscious disregard for public safety. That is fully regarding public safety and attempting to balance the obligation to pursue and apprehend people with outstanding warrants with that countervailing interest in public safety. Notably, too, I didn't mention it before, but there is the estate of Fritz case, which is a first-party collision case, but it's in federal court, but it's applying Iowa law. And that case holds speeding through an intersection by a law enforcement officer with lights and sirens activated is insufficient as a matter of law to demonstrate recklessness. So at the summary judgment stage, that's how that case was decided, and that is a gold standard indicator that under Iowa law, recklessness is just so high a standard. Just as you all might be concerned about this, what does this mean we can pursue a shoplifter in a school zone? The flip side of that, as counsel's argument illuminated, is that even a person suspected of major crimes couldn't be pursued at all. And really what this harkens back to is the West Virginia federal court in 1967 with the colorful language talking about opening the door for every desperado seeking sanctuary in congested confines of municipalities. And what the court held back then is that is not the law, nor should it be the law. It shouldn't be the law in Iowa either, and it isn't the law in Iowa, and you should reverse the district court. Thank you.
The case of Martinez versus State is hereby submitted, and we'll have a brief transition to prepare for the case of State of Iowa versus Thompson.